Welcome to Rajput, Jain and Associates. In this video, we'll discuss about appointment of independent director, its qualification and disqualification. So let us begin with the meaning of independent director. An independent director is a director who is not aligned with either the management or the promoters and is capable of exercising independent judgment. So, independent director is a non-executive director, that is, a director who is not involved in the day-to-day functioning of the business and who has the expertise, integrity and independence to balance the interests of various stakeholders. So, what are the key responsibilities of an independent director? The key responsibility is to ensure that the management and the board take decisions that are in interest of all the shareholders and do not favor any one class of shareholders. Now, having discussed about the meaning of independent director, we come to the appointing obligation of companies in respect of independent director. So, as per section 149 subsection 4 of Companies Act 2013, every listed company is required to appoint at least 1/3 of their total director as independent directors. However, it is to be noted that such requirement does not apply to Section 8 companies. Also, as per Rule 4 of the Companies Rule 2014, public company which is having paid up share capital of rupees 10 crore or more, turnover of rupees 100 crores or more, outstanding liabilities, debentures and deposits of rupees 50 crore or more is required to have at least 2 directors as independent directors in the board of directors. Next, we'll discuss about qualification of independent director. An independent director shall possess appropriate skills, experience and knowledge in any one or more fields of finance, law, management, sales, marketing, administration, research, corporate governance, technical operation or other disciplines related to company's business. Moreover, whenever independent director is included in the constitution of an audit committee, they must be financially literate. That is, they should have the ability to read and understand financial statements. Also, the independent director should be minimum of 21 years of age. Next is appointment of independent directors. While selecting independent director, the board shall ensure that there is appropriate balance of skills, experience and knowledge in the board to enable the board to discharge its function and duties effectively. The appointment of independent director shall be approved by passing an ordinary resolution at the meeting of the shareholders. The explanatory statement attached to the notice of the meeting for approving the appointment of independent director shall indicate justification for choosing the appointee as independent director. The appointment of independent director shall be formalized through a letter of appointment which shall state that the term of appointment of director, the expectation of the board from the appointed director, the board level committees in which the director is expected to serve and its task, the fiduciary duties that come with such an appointment with accompanying liabilities, the code of business ethics that the company expects as the directors and employees to follow, the list of action that a director should not do while functioning as such in the company, and the remuneration and mentioning periodic fees, reimbursement of expenses for participation in boards and other meetings, and profit-related commissions if any. After that, the company should make necessary entries in the Registrar of Director and Key Managerial Personnel and Register of Contract and Arrangement in which directors are interested in Form MBP4. Company shall regularize the appointment of additional independent director in the next annual general meeting. After the general meeting, a return of appointment of directorship is required to be filled with the registrar within 30 days of appointment, with a copy of ordinary resolution along with consent to act as director and declaration about his disqualification. Now, for filling form DIR 12, the following documents are required to be attached, that is, certified true copy of ordinary resolution passed, DIR 2 consent to act as director, DIR 8 declaration by director, letter of appointment. Now, another important aspect is disqualification of independent director. All the disqualifications prescribed by section 164 with respect to directors shall apply to independent director as well. However, listing agreement provides that an individual cannot become an independent director in more than 7 companies. Apart from this, independent director will be disqualified where the person is of unsound mind or is declared so by the court. The person is insolvent or is in the process of declaring insolvency and his application is pending. The person has been convicted by a court of any offense and has been imprisoned for at least 6 months. However, if a person has been convicted of any offense and has served a period of 7 years or more, he shall not be eligible to be appointed as director in any company. Also, if an order has been passed disqualifying him from being appointed as director by court or tribunal. Apart from this, if a person has not paid any calls with respect to any shares of the company held by him, whether alone or jointly with others, and a period of 6 months has elapsed from the last date fixed for the payment of the call. And lastly, the person has failed to acquire director identification number. So next, what is the tenure of an independent director? An independent director shall hold office for a term of 5 consecutive years. The same person is eligible to be appointed for another term of consecutive 5 years by passing a special resolution and would require a disclosure of such appointment in the board's report. An independent director shall not hold office at a stretch of more than 2 terms of 5 consecutive years. After the completion of the said tenure, the same can be appointed after a gap of 3 years. Finally, we come to the liability of independent director. An independent director and a non-executive director, not being a promoter or a key manager person, shall be held liable only in respect of acts or omission, or shall be held liable only in respect of omission or commission by a company which had occurred within his knowledge attributable through board process and with his consent or connivance, or where he has acted diligently. So this was in brief about independent director appointment, qualification and disqualification. If you want to know more about it, contact Rajput, Jain and Associates. Thank you.